My lady, my lords, yesterday I took you through, as it were, my positive case on my appeal, and so this morning I intend to turn to Mr. Glazer's arguments in opposition to our appeal and what I say in relation to them. There are a number of them, and I obviously need to go through each of them with you. The first argument advanced on behalf of the wife was articulated in opposition to the permission to appeal application by my client, and that was put on the basis that IRB's appeal was premature or misconceived, in that instead of appealing, someone, it's not quite clear who, should be seeking to set aside the court's 15th of December order pursuant to Rule 9.9A2 of the Family Procedure Rules. So I can just take you to how that argument was put, and that's in the second supplemental bundle at page 702. So you'll see this is the wife's points in opposition to our permission application. And you'll see it, paragraph 2, it said that our application permission is misconceived and premature when Mr. Justice Cohen had not actually made any decision of the kind complained of. The court's order presently reads in the recitals, and then it's set out, and then it says no decision has been made against which IIB can properly appeal. This recital, whose true effect is to stay a decision on this question, does not contain any decision of the court. It would only be after the court imposed terms on IB.
I don't think, for my part, you need to address it any further on that.
I'm grateful in that case, my lady. The other point I think made in this document is that, that I might need to address you on, is that we should have been applying to set aside the first instance court under 9.92A of the Family Procedure Rules. I say, obviously, that's not right. The set-aside jurisdiction of the court is in any event permissive only. It's not mandatory to apply to set aside a financial remedy order pursuant to 9.9. It's simply a provision that says a party may do so. In circumstances where the judge has made an order, which we say here no jurisdiction to make, we're plainly entitled to appeal from it. And so unless Mr. Glazer is going to develop those arguments any further, they're obviously not repeated in his main skeleton in response to the substantive appeal I'm making. I don't think I need to address you further on them. If he does seek to make further points in relation to those sorts of contentions orally, I reserve the right to respond in reply myself.
I think you probably more politely mean you'd like to have the opportunity rather than positive.
I would like to have the opportunity, my lord, yes.
You reserve the right.
Indeed, my lord, yes. Now, the other arguments in this document, I think, are repetitious of the arguments in my learned friend's more current skeleton, so I'll turn now to that. So if we can go to my learned friend's main skeleton, the core bundle, at page 325, please.
You could use paragraph numbers for me, please, because I've got mine separate.
It's paragraph 2 I was going to start at. So under the heading the bank's appeal, the first argument is that we bring this appeal on the basis we effectively had our fingers crossed when leading counsel made what's described as a concession to the judge that I did. That's said to be profoundly unattractive, and it's then said that can only have been a decision, the decision to appeal, paragraph 10, can only have been a decision made by the husband as CEO majority shareholder in concert with the board of directors. Now, 2 points on that. Firstly, my lady, as I said yesterday, in no sense did we make our proposal with our fingers crossed. It was a bona fide proposal made to meet the concern the judge had expressed during the trial that the husband had no available capital from which to rehouse the wife and the children, in the event the court found the FAP to be valid, and thus that the equity in it belonged to the bank and not to the husband. And as we've seen, it was a proposal which the wife chose herself to reject. But she didn't make her rejection clear to either the bank or the judge at trial. but only by her draft order of the 5th of December, following the hand-down of judgment. Secondly, the decision to appeal of the bank was not that of the husband, and he has taken no part in it. And as I made clear below, IIB has excluded him from decision-making in relation to these proceedings, including in relation to the appeal, because he's obviously conflicted. It would be in his personal interests, indeed, for IIB to be forced to provide for W, for the wife, on whatever terms the court ordered. If you like, he'd only be bearing 60% of the cost of that, because he's only a 60% shareholder. So the other directors have taken the decision-making in relation to these proceedings, including this appeal, and not the husband. And I just wanted to make that clear to the court, given what Mr. Glaser says. Thirdly, in this paragraph, he says that we, by our appeal, seek to resile from our agreement to provide a settlement which provides for the wife and the children. That, in my submission, is a fatally flawed submission. As I submitted yesterday, there is no agreement from which we are resiling. Notably, in Mr. Glaser's submissions, he repeatedly says we're seeking to resile from an agreement without identifying the other party or parties to the agreement. But if we move on to paragraph 8 of the skeleton, one way in which he appears to be articulating this is that we, as he says, effectively made a plea bargain with the judge below.
Yeah, I'm not sure I understand that really, because if the wife had succeeded on her case at first instance that the FAP was a sham, that would have resulted in the beneficial interest in that property being wholly the husband's and
Indeed.
not the bank's. So you wouldn't have had anything to do in any event in those circumstances.
Quite, but my learned friend's case appears to be that the offer, as he describes it, that I made to the judge was accepted by the judge and led the judge
Oh, I see.
to not
deal with
find
the
a
judge,
sham.
basically.
I mean, it appears effectively to be an allegation that the judge corruptly, as it were.
Well, I think that's putting it a bit high.
Well, I mean, it would be a betrayal of the judicial oath that the judge had taken. He was...
Yeah, corruption's the wrong word, but you mean he allowed it consciously or subconsciously to influence his decision-making on a principal factual issue in the case?
Factual and legal issue, yes. Yeah. He purported, as it were, to try out fairly and properly the sham case, but in fact reached a conclusion he would not have reached in order, as it were, to
ensure
capture...
the protection of the wife and children.
Quite, exactly. That didn't happen. If that had been, as it were, what I was seeking to do with the judge and which he had entertained, he would have said, I don't need to try the sham case because Mr. Richardson has provided for housing for the wife and children, so I'm going, if you like, to accept that offer, say I'm not trying the sham case, and make an order that Mr. Richardson's clients provide housing in the way that he has articulated. That isn't what the judge did at all.
But you weren't making an offer to the judge anyway.
I wasn't making an offer to the judge anyway. But this is one of the arguments Mr. Glaser seems to be running.
Well, we've read that paragraph.
Yes. But I just want to make it clear that that's my answer, as it were, to it, my lord.
I mean, it would have been possible to have made an offer contingent on the wife deciding not to pursue the sham case.
Yes.
In entirely different factual scenario, but that's not the offer that was made, and that's not what happened.
No, the sham case proceed. Well, for a start, it's important to remember, obviously, that the offer I made, as I said yesterday, was made at 2 p.m. on the final day of the case. So everything in relation to the sham case in terms of evidence had already been set out and explored with the witnesses, and Mr. Glaser proceeded to make his submissions on his sham case to the judge. So the sham case was fully tried out by the judge. And I suppose I should conclude on this by saying that in paragraph 8, this whole contention appears to be predicated on the fact that my offer, the offer, as it's described, was especially couched on the basis the FAP was valid. It's obviously right that I said this offer is being made premised on you finding the FAP is valid, but as my lady said, that's because if it wasn't valid, then the house was the husband's and it was available to provide to the wife.
Yep.
So that was simply a...
Well,
yes,
then the court could have simply made a transfer of property.
Quite maybe, yes. In paragraph 9, it's then said that the offer contained, quote, an implicit concession that IIB might be made subject to a settlement of property. Now, insofar as I can understand that, I say that's simply wrong. For a start, people, whether persons or corporate bodies, are not made subject to a settlement of property by the family court or any other court. The family court, of course, has a very limited jurisdiction pursuant to section 24(1)(c) of the Matrimonial Causes Act to vary an existing nuptial settlement, that is, an existing settlement of property on one or both parties to a marriage. Ahmad, you haven't got it before you, but I'm sure you're familiar with the terms of that provision. So where the wife says there's jurisdiction here, she says here, there's a jurisdiction to order a third party to settle property in favour of a party to the marriage, that is exactly the effect of the court's powers under section 24(1)(c) of the Matrimonial Causes Act to vary a nuptial settlement. We say that's plain wrong. The court has no power to order a third party to settle property or to create a settlement of property in favour of a party to the marriage, let alone to order it to do so and then exercise a power to vary that settlement. There's absolutely no authority cited by my learned friend, and it's plainly a
I'm not
bad
sure that's
submission.
pursued in any event, given the way it was put in opening at the actual trial, as was drawn to our attention by Ms Bangay yesterday.
Well, it is being pursued in my learned friend's skeleton argument here. I say it's also not open to him because he abandoned any nuptial settlement argument.
Which is why I say
trial.
I'm not sure if it's still being pursued, albeit it's in the skeleton.
Well, again, if it is pursued, I may need to come back to it. I don't seek permission to come back to it, but if it isn't, I can move on. In paragraph 10, we're then told the case is put alternatively on the basis that IIB, quote, conceded that they would consent to a settlement. It's not clear what that's supposed to mean, but I say it's, again, misconceived. We didn't consent to the court creating a settlement of property owned by us, whatever property is supposed to be identified there. To the contrary, we made it perfectly clear we reached no agreements with the wife, and the court had no jurisdiction to order my client to reach an agreement with her, or itself to order provision by my client for her. If we then move on, I think, to paragraph 21, it's actually the next paragraph because it's misnumbered in the document, so the first 21, as it were. We're then told that there's nothing problematic with what the court ordered because, quote, the court has the power to implement an agreement and to construe the contract in the event of doubt or where the parties cannot agree. So this appears to be a different argument to the nuptial variation argument that's been run previously. It's equally misconceived. There is no contract here for the court to construe. It's a simple point. As I've said again, and I'm repeating myself, but we made a proposal of specific terms on which we would be willing to rehouse W if she agreed with us. Even assuming that to be a contractual offer, as we've seen, she did not accept it. There was no meeting of minds to form a contract at any point. And paragraph 10 of the order, of course, is not in any event a provision directing that there be some sort of construction application made to the judge. It is a direction that the parties seek to reach an agreement and make a contract, and if they can't, for the court to make the contract itself on their behalves, as it were. And that, as I say, obviously is what the court has no jurisdiction to do. And so that leads to the logical fallacy, I say, in paragraph 11, where it said that in the event the parties were not able to agree, the court is thus able to determine the terms of the agreement. That's plainly wrong. Construction principles have nothing to do with what the court has ordered by paragraph 10 of the 15th of December order. We then have the section headed the bank's real appeal. Now, much of that is repetitious of the preceding section, but just looking at how it's put here, because it's put in all sorts of different ways, there's an emphasis in paragraph 12 and elsewhere on the notion that we're seeking to resile from an agreement. Again, not said with whom that agreement was made, and as I said, there was none. It's then put on the basis that we're seeking to resile from a concession. But there was no concession, as my lady, my lords, shall appreciate, a concession arises when a disputed fact or matter in issue between parties is conceded by one of them. But there was no claim made by the wife that my client was obligated to rehouse her, and there's no fact or matter between my client and the wife which we conceded at any point. The proposal we made was a proposal. It was not a concession of anything in issue as between my client and the wife. In paragraph 13, it's then said that had we put the availability of the jurisdiction of the court to take up our offer into dispute, the wife would obviously have made submissions on the same, and she might reasonably have done one of more of the three things specified: obtaining clarification as to whether we considered our position was enforceable, inviting us to offer an undertaking or to withdraw the concession, and inviting us to recite their offer acknowledge the existence of a nuptial settlement. And then it said it's clearly self-evident the final hearing would have been conducted differently had we sought to put in issue the points that we now wish to raise on appeal. My lady, my lords, that totally misrepresents what took place. As I've already said to you, the judge sought IIB's proposal partway through, in fact right at the end of the closing submissions, and in the course of the wife's closing submissions on the 27th of October, specifically so that Mr. Glaser could hear what I said and respond to it if he wished to do so. It was the wife who failed at any point in her closing submissions to make clear that she did not agree with what was being proposed and did not accept key elements of that proposal. And she kept silent as to her position, as I said, until the 5th of December. Had she made her position clear before the trial concluded, then obviously my client would have done none of the things that it's being suggested it would have been asked to have done at A, B and C. We weren't going to enterprise any of the things at A, B and C. But we didn't know that the wife wasn't accepting what we were putting forward, and nor, I think, did the judge. And we also say that the notion that it is self-evident the final hearing would have been conducted differently had we sought to put in issue the points we now take on appeal is also misconceived. The skeleton doesn't say how the trial would have been conducted differently. So far as the judge was concerned, we say it plainly would not have been. He tried out the sham case fully and fairly, and he made the finding that the husband could afford a £6 million lump sum based on the wife's submissions about the blocked accounts. The wife doesn't begin to suggest what other findings the court could or should have made. Likewise, we say it's not right that the wife would have run her case differently. As we've seen, she disavowed the nuptial settlement claim on day one of the trial. She ran her sham case in relation to the FAP in full, fully arguing it before the judge. She ran her case in relation to the ESOP, and that being a resource, fully at trial, and again the judge gave that proper consideration. She ran in closing her case that the blocked accounts in H's and husband's name were in fact real accounts, and she succeeded on that claim. And again, as I say, my proposal was only made at 2 p.m. on the final day of the hearing.
That's really the best point, isn't
Yeah, it is a unarguable point.
In terms of the timeline.
Yes. And as I say, Mr. Glaser made the submissions he continued to make on that day, including in relation to the sham case. So we say the notion that the final hearing would have been conducted differently doesn't withstand scrutiny. Paragraph 19, then moving on, which is really the conclusion of these submissions, really trespasses upon the permission to appeal application that my own friend is going to advance. We obviously say it's a thoroughly bad application, but I don't propose to address you in relation to all of those arguments at this stage, unless obviously you'd like me to. What I do need to address is this, that just before 9 o'clock yesterday evening, we were sent a new authority by my own friends, Malik, exactly, with which obviously you'll be familiar, my lady. It's obviously unsatisfactory in my submission that a new authority which appears to be seeking to run an entirely new legal argument is only provided at 9 p.m. on the first day of the hearing. but I'll deal with it as best I can now. I say it's not an apt or relevant authority to this case in any event on its face. As you may recall, my lady, and as you can see from the headnote, it concerns the species of estoppel by conduct and abuse of process which arises where a party has set out a position in one set of proceedings which leads the court in those proceedings to make a particular order or finding, and then that same party seeks to take the opposite position or a different position in a second set of proceedings. And it's the species of abuse of process in the second set of proceedings for the parties to so resolve from the position that they put to the judge and that was acted upon by the judge in the first set of proceedings. And we can see that, my lady, from, I think, page 415 of the report. This is Lord Justice Saccaroli's judgment, and he's obviously referring to the hearing before the Mrs. Justice Bacon below. And he says it's common ground the question whether a person is precluded from advancing a position in one case where they advance the opposite in an earlier case is to be answered by reference to the principle set out by Sir Christopher Floyd in the microgroup case. And you'll see from the quote where he says this form of estoppel by conduct is one which is approached in the broad way that the court then articulates. And you'll see over the page at paragraph 36, having considered counsel's arguments, the Lord Justice Saccaroli here says ultimately the label is unimportant. Although Sir Christopher Lloyd did not use the phrase the form of estoppel by conduct in issue, that is, the very limited form of estoppel by conduct that was live in this case, can readily be seen to be a species of abuse of process. So this is an authority which is relevant to that narrow form of abuse in successive proceedings. It's not, therefore, an authority relevant to the current case, which is not a case, obviously, of successive proceedings. In any event, I say there's no question of my client adopting anything inconsistent with the position that it articulated through me at 2 p.m. on the 27th of October. We made the bona fide proposal we made then. The judge clearly thought it was a good idea and recorded it in his judgment. The wife chose to reject it. Ultimately, my lady, my lords, all of my learned friends' submissions in opposition to this appeal, including this one, are at heart attempts by the wife to escape the inevitable consequence of her own decision to reject the proposal that my clients had put forward, and indeed to do so twice, both after we made it at court and then when we renewed it after judgment on the 12th of December by Ashford's letter. There is nothing unconscionable, still less an abusive process of the court, for my client to appeal against the excess of jurisdiction the court below fell into by paragraph 10 of its order following the wife's decision. Now, that may have been a foolish decision, but it was her decision to make. She made it, and these consequences flow from it. My lady, my lords, I was going to conclude, as it were, by summarising everything I said to you yesterday and this morning, but I probably don't need to. I can see I'm not being encouraged to, so I shan't. The only thing I thought I might say is what we say happens were you to allow our appeal.
Yes, well, we wanted to discuss that with you as well. So you go first, and then I will...
I'm grateful. Well, our appeal is only on its face and in substance an appeal against paragraph 10 of the order. So we say that the judgment of the court should simply be to set aside paragraph 10. As we discussed yesterday, the undertaking in paragraph 11 given by my client then, as it were, falls away, but there's nothing this court need or can do in relation to that.
By falls away, you mean it becomes extinguished?
Becomes
because of
extinguished.
The way it's worded.
Precisely so, my lord, yes. Paragraph 12 remains in place, as we discussed yesterday. I was reminding myself of reading it properly overnight. That is a provision which is tied to both the husband's and the wife's appeals in this case. That's how it was put. And essentially what it says is, if the husband appeals, and then if the wife appeals against the sham finding, nothing happens in relation to her undertaking there until those appeals are being disposed of. But once you have disposed of those appeals, then she has undertaken to apply to remove the restriction over the property. And as we discussed yesterday, that restriction, if it were ever in fact something legitimate and that she was entitled to seek, can only have been predicated upon the sham case. Because if in fact the bank is the beneficial owner of the property and the husband is not, then the wife has no basis to put a restriction on title. Now, I understand from Mr. Glazer's exchanges with you at the end of yesterday, and then from discussing with him outside court, that his position is that if you allow my appeal, you should then, in fact, without him moving his appeal, remit everything back to first instance. So, in fact, you should not just set aside paragraph 10, but you should set aside the whole order made on the 15th of December. And there should be then a full retrial, it appears, of everything, including the sham case. In my submission, that is an absurd stance to take. The only circumstance in which paragraph 13 of the order, that's the provision declaring the FAP to be valid, the only situation in which that should be set aside and my client forced to relitigate that issue is if Mr. Glazer succeeds on his permission to appeal and then on his appeal on behalf of the wife in relation to that case.
Is that quite right? Because if the court allowed the husband's appeal on particularly ground 1, the fairness, that it's hard to see. We've heard Ms. Bangay's submissions about limited remitting, but presume for a moment we felt that was not practical and that it would have to be, no matter how horrific the thought is, a retrial. Once there's been unfairness in a trial, that contaminates the whole case. And so surely there has to be a retrial on everything, and presumably that's why Mr. Glazer's saying, then you don't need to determine the forward acquisition property agreement, because that would have to fall away because the whole trial has been contaminated by unfairness.
I was going to, so my submission, if you like, was predicated, and I should have made this clearer, on you allowing my appeal but not allowing the husband's appeal. If you were to allow my appeal but not the husband's appeal, then it seems to me it would be absurd to suggest that everything gets remitted for retrial. There was a fair trial on that footing of the sham
on that
case.
basis there would be a fair trial. But
Right.
do you accept my proposition that in the event that the husband's appeal was allowed, the whole lot would have to go back?
No, my lady, because, as I say, it was an accident of timing that the sham case got tried at the same time as a financial remedy case between husband and wife. Our case, if you like, was a chancery action that needed to take place.
It was heard when it was heard.
It was heard when it was heard.
It may have been more advantageous to you here today if it had been heard as a preliminary issue, but it wasn't.
But the unfairness, if there were unfairness, as you find on the husband's case, was all directed at the blocked accounts and the judge's findings in relation to that issue. There's no suggestion by my learned friend Ms. Bangay, or by my learned friend Mr. Glazer, that there was, if you like, that sort of procedural unfairness in relation to the trying of the sham case. Mr. Glazer says, I wrongly persuaded the judge not to find for him on the sham case because of my proposal, but that's his appeal. If you reject his permission to appeal or his appeal on that basis, then there's no reason to disturb the judge's findings on sham, and my client should not be sacked.
There's some high authority against you on If the husband's appeal on the basis of procedural unfairness succeeds, then it means the trial was unfair. And the Supreme Court told us in Serafin, what order should flow from a conclusion a trial was unfair? In logic, the order has to be a complete retrial. You can't disentangle a strand of unfairness and say unfairness only impacted this element, because that's exactly what the Court of Appeal did in Serafin, and the Supreme Court said it's impermissible.
I understand that, my lord, but my submission is that, in effect, there were two trials going on in October 2023. There was the trial as between my client and the wife on the sham case in relation to the FAP, and then there was a trial of the financial remedy case as between the wife and the husband.
And one of those was unfair and one wasn't, is that what you're saying?
Precisely so, my lord, yes.
Interesting.
Okay. May I just ask you then about paragraph 12 again?
Yes, my lord.
If your appeal succeeds, the position will be that the bank is the owner of 100% of the beneficial interest of the property and has no obligation, unless they choose to take up an obligation, in relation to the wife, towards the wife, or in relation to that property. And your claim is against the husband solely, because he's in breach of the terms of the forward acquisition property.
He's not at present, because the long stop date in that agreement was extended, I think, last year to, I think, 2029.
But have we got that document in our bundle?
I don't think it's in the bundles, well, no. I'll double check I'm right about that.
Could you just give me, I may have missed that. Could I just have the dates when
Yes.
that agreement was reached?
I'll get those for you, my lady.
And the exact date that
Yes.
it was extended to. So your claim would be against the husband, but the position
Yes.
is at the moment.
At the moment, we're not seeking, as it were, to bring completion forward. We say, in any event, the 100% beneficial owner in the property, and he's simply holding the paper title for us.
So is it, in the event that your appeal was allowed, is it your submission, as I understood it a few moments ago, that the wife would not be entitled to have a restriction
Yes,
in law?
in law, yes.
Because?
Because you have to have a form of claim which entitles you to put a restriction to stop dealing with title to the property. If you don't have something that entitles you to say that the property should not be dealt with, you're not entitled to put a restriction on the register.
So what you say is that the restriction effectively was part of the litigation because she only had an entitlement to any sort of long-term restriction.
Yes, my lady.
If it was established that the husband, in fact, was
the
the
owner.
beneficial owner.
Yes.
So if your appeal is allowed, you say 12 has to go, or
Yes.
that has to be complied with. I mean, we keep saying go and stay, which I
Yes.
think is confusing all of us.
Yes.
But the restriction
Yes.
has to go.
Yes, the,
because again,
suspension on its effect goes, exactly, yes. I've been had a note saying that...
And if, however, the forward acquisition property was to be re-litigated in any form, then 12 could stay.
If
It
you...
would have to be redrafted in terms of
Yes.
until after, but you would not seek to say that it would be inappropriate
Well,
for it to remain, if it was once again at large, whether or not the husband has in fact a beneficial interest.
I think, yes, my lady, in the sense that this is an undertaking by the wife to do something, we wouldn't seek to say that she should do that thing regardless of remission for a
Yes.
full retrial.
Well, you wouldn't be making an application that to discharge the restriction on the basis that there was no jurisdiction to make it.
Well, I'm not sure I've got instructions to give, as it were, an undertaking to that effect.
No, I'm not asking
But-
goodness
but-
me. After
but we
everything we've been
haven't-
through, I'm
we
certainly
haven't to
not
date.
asking.
We haven't to date,
I'm
as
just
it
trying
were.
to work through,
Yes.
I think we're all trying to work through consequences of various different outcomes.
I mean, regardless of whether the wife's case in relation to sham does or does not entitle her to put a restriction on the register, my client has not to date sought to remove that restriction because, in effect, until this issue is finally determined,
Who knows?
Who knows? And it's not going to be dealing with the property anyway.
Quite.
Yeah.
All right. Do you want to ask anything? Do you want to ask anything else about that?
When you say it's not going to be dealing with the property anyway, is that on the basis of the date you were about to give us because your junior put it on that yellow sticker as to when the long stop date is?
That's not what I was being handed, my lord. No, I'm being told that S12 explains the position on restriction. It's in paragraph 28, I'm told, of the wife's skeleton. So we just have a look at that, it may be helpful.
Supplementary bundle.
Supplemental, I assume, supplemental bundle, page 12.
And where would you be? We all be without juniors that know the papers inside out.
Okay. So that, indeed, that tells us that, as the court knows,
Paragraph number?
paragraph 28,
Yes.
the court apparently directed the land registry to put a restriction on the property.
Yes. And that, well, that's conventional, isn't it?
Yeah.
It's to
Yes.
preserve the proprietary right.
Yeah.
And the resolution of whether there is one or not and what the order should be.
Yes, quite simple.
So if this were, as my ladies said, to be remitted, the logic of the restriction remaining in situ applies until there's a final resolution of the issues between the husband and the wife about the status of the beneficial interest in the property.
Well, or more particularly, as between the wife and my client, as the status of the beneficial interest in the property.
Yeah, yeah, because that's why you were joined in the first
Yes,
place.
I mean, the husband's not claiming a beneficial interest in the property. Yeah.
Thank you. Anything else? No? Thank you very much, Mr. Richardson. Very clear.
Thank you.
Now,
My lady,
Mr. Clates.
my lords, the first, I believe, and we're checking, but the first that we heard that the forward acquisition property agreement had been extended to 2029 was about 60 seconds ago.
So I hadn't failed to read it in the bundle then.
Well, no. I need to take some instructions from my client because it's a very relevant change in circumstances, which we're just talking about now. I mean, if, for example, the bank was to agree a variation to the FAP to 2032, subject to instructions, it may render the bank's appeal and my position unnecessary. Because my client would then essentially have the right to occupy the property because until 2032, which is essentially what the judge...
What, because that's when the GA money is supposed to be coming in?
No, because the terms of the offer, or agreement, or concession, or whatever you want to call it, by the bank, was to allow to purchase a new property until 2032. That was I don't want to elevate it to a technical word, but that was the deal, the agreement, the understanding, the arrangement.
Well, which you rejected out of hand.
Well, we didn't reject it. I mean, I'll come to those submissions in a minute. But if the bank was now to say, well, we will extend it to 2032, for example, then it may short circuit everything that's going on today. So the first we've heard about an extension, because the existing agreement expired on the 3rd of February 2024.
Which was why I made that comment.
Of course. So maybe the bank can take some instructions and I can talk to my client in light of this very important development.
My lady, I hesitate to interrupt Mr. Glazer, but my instructions are that the extension was only till 6 months after the resolution of all legal matters, and we can provide a copy of that for your ladyship.
Well, I'm just being told by Mr. Richardson it's 2029.
Well,
I did say I might not be right.
yes,
I need to
he
take
did,
instructions.
and I've taken specific instructions from my client.
Okay, well,
And we'll provide your ladyship with a copy of it.
yes, well, I think what we've got to do, Mr. Glaser, is you carry on with your
Very well.
submissions overall.
Very well.
I mean, you've still got all the husband's appeal to deal with.
Yes.
And Miss Bangay kindly is making inquiries about that. When we've got that document, if needs be, we're very happy to rise for a few minutes in order for you to take instructions about it.
Can I just deal with... No, I'm going to start in a different place. This trial, I'm going to deal with the husband's appeal first.
Thank you.
This trial was quite an unusual one in lots of respects.
Well, the outrageous amount of costs is one of them.
Yes. And I want to first address the suggestion that the husband did not know it was an issue.
Yep.
The husband had, and Mr. Hussain had made statements saying that an account existed, past tense. And my lady and my lords have looked at that. Can I ask you to look at supplemental bundle, page 152.
What document is this?
This is the husband's replies to the questionnaire.
All right. Thank you.
And at G, a specific question was asked about the bank account. And he was ordered to identify the account and provide copy statements. And rather than saying there was no account, and that was all a lie to the court by both the bank and the husband, the response came back: the blocked account was a voluntary explanation of the financial accounting entries created. So again, past tense, there had been entries created in the bank's books. And he knew it was an issue because it then goes on to say the group's external auditors for their banking subsidiaries were asked to undertake a special review. Now that was something which Sir Jonathan Cohen considered as part of his judgment, where he said, well, if they didn't know it was an issue, why did they undertake a review? But it was still maintained, and this had a statement of truth attached, it was still maintained that there was something tangible in the bank's books, entries created in relation to these accounts. And what then happened, and I don't want to take my lady, my lords, down a cul-de-sac, but it is important. The husband said that the letter was in documents that he had left at the former matrimonial home, and the wife had improperly looked at those. And I don't want to go down the road of whether it was improper or
But
not.
he says elsewhere he thought it was destroyed.
Sorry?
He said elsewhere he
I know.
thought it was destroyed.
But the point of saying that was subsequent. The point of saying that they're at the home is relevant to what happened in terms of the documents at my client and the husband's former matrimonial home, because that was the subject of a very extensive, for want of a better word, Immerman dispute. So those documents were all boxed up. We then said in terms that the husband's team have an obligation following UL and BK to examine those documents and to produce any documents which are relevant to the proceedings. And if my lady and my lords then turn to page 531 of the supplemental bundle, which is the order made at the pre-trial review on the 27th of July, and this was the first time that I came into the case.
531.
531, my lord. That's the part of the order I want to take you to, but just for reference, it's the order of the 27th of July 2023. At the pre-
This is the one part of which you quote in your skeleton, yes?
Yes.
And you want us to look at the bottom of 531 and item Roman 8 on 532.
Yes. So the husband's solicitors had refused to carry out the obligations put upon them by UL and BK to examine the documents, to provide any that were relevant or touch upon the issues in the case. So Jonathan Kern ordered them to do so.
Just help me on this one. Were you ever given a reason why the normal procedure of reviewing the amendment documents wasn't going to be undertaken?
From memory, it was, there's quite a lot of them, it's quite expensive. From memory.
Proportionality argument.
Yes.
I think is how they would put it.
I mean, we see level in court today, notwithstanding the assurance or the representation made to my lady on the last occasion before the court, that if we got paid any money, those ceased to act, but they're still here.
Lady, that wasn't what we said. What we said was that if we were to raise money for the wife, then some would have to be raised for my client's solicitors, and that's what happened.
Well, I think my Hadkinson judgment has exactly what was said, so I don't think we need to argue about it now.
So,
my understanding was that your instructing solicitors had to be paid in full before anything went.
They had to be paid some money, my lady.
My judgment says what it says, which
I'm
was
going to
written
remind
immediately
myself.
after that hearing, and no appeal was made, and no one asked for clarification or suggested my judgment was incorrect. So I regard that as an accurate record of your solicitor's position.
and the judgment is page 774, if needs be,
Thank you.
to reference. And I just pause there that the husband remains in breach of a number of orders to pay costs to my client, and those are not under appeal. So the idea of paying his own solicitors in...
Well, I think this
maybe
is
that's
I think this is a cul-de-sac, and
Very
also
well.
it ups the temperature.
Very
So
well.
let's just.
I'll return to page 531.
Right. So they'd refused to carry out.
They'd refused to carry out, and we still at that point understood that the letter in question, and it was singular, was in the Immerman documents, because that's what the husband said where it was.
Just a minute.
So the singular, it was in the reply to the question, was it? Is that what you're saying?
No, the singular comes at page 110. If you want to turn to that, we can look at that
Is
now.
that his witness statement?
Core bundle.
21?
Yes.
So in that's where we get, because I raised that with Miss Bangay yesterday, didn't I? Was, has the wife ever conceded that she saw the letter? Because the husband's case in the two witness statements was that she knew of the letter because of the Immerman material.
Yes, and if we can see that, it's not 1, 2, it's my mistake.
Where are you taking us? I lost track.
I'm so sorry, my lord. Core bundle,
Yeah, I got that bit.
husband's witness statement, and at page 109, paragraph 231, he talks about the blocked account.
No, I'm in the wrong place.
The one that begins, the only other meaningful bank account
Yes.
I have is an account with one of the subsidiary banks, which IIB owns.
And over the page,
Yeah.
at 232, that was just
The letter.
context.
Yeah.
The letter.
That's the reference.
Yes.
She had in the past asked about a letter from the bank.
Yes. And then if my lord then goes to page 125, this is the statement of the second statement of the husband in relation to the legal services provision application, the LASPA application.
93.
93.
Lasbury statement.
Precisely, my lord. He says that it would expose her to the Immerman issue, so those documents, the suggestion is that that document is within the papers that have been boxed up. And then again talks about a letter. So back to, if we may, 531 of supplemental bundle.
The order.
The order. The respondent solicitor shall review both documents in dispute and additional documents and disclose to the applicant and the second respondent all and any documents which assist the applicant's case, whether directly or indirectly undermine the respondent's case, whether directly or indirectly or otherwise relevant to any of the issues in the proceedings.
So this is the order that I was discussing with Miss Bangay yesterday.
Yes.
In relation to the husband's duty to disclose.
Yes, precisely. But it goes further, because what Miss Bango said is, well, you never asked for the letter. You could have asked for the letter, and I want to demonstrate, if I may, or try to my lady, my lords, that we did.
Well, there was an order which covered it.
Precisely. And it covered it in two respects. One was subparagraph 2
Of, sorry. Oh, yes.
532.
Page 52.
Specifically.
Yeah.
And subparagraph 8.
Roman 8.
Roman 8, I'm so sorry. Roman 8. So there is a specific reference to the letters, to the disputed, the cash account, and to any other documents generally. Now, the bank was a party to the proceedings at the pre-trial review, was at the pre-trial review, represented. We didn't know that the letter was held by Mr. Hussain. But it must have been obvious to anyone following that order that we wanted to see it. It was an order against the husband. I won't get into a debate about possession, custody or control. Clearly, Mr. Hussain, the bank, had an obligation following this order to consider if they had it. But there can be no doubt that the husband knew that the disputed accounts were an issue and we had been asking for the letter.
It's covered by the word documentation, isn't it? So
Yes.
that could include accounts, letters,
Anything.
negotiations.
Anything.
Well, and you expressly relate it to paragraphs 231
Yeah.
and 232.
Yes.
Yep.
Any documents concerning the account, which must include, as far as we were concerned, the letter at that stage, which we had understood because we were told that it was in the EMM documentation.
Well, it also says in paragraph 5 on 531, all and any documents,
Yeah.
etc. And then it goes on to say which include.
Yes. So the husband well knew at that point that the question of the disputed accounts was relevant. We also know, if we look at page 497, and this is part of the cross-examination of the husband.
Sorry, just a moment.
Sorry.
Supplementary bundle 497. Sorry, I have
Yes,
my
my lord.
orders
My lady.
separately. Thank you.
This is my cross-examination of the husband. He says to
Which here? Where?
D.
When was it?
Um,
I see. At the hearing.
yes, at the trial.
Yes.
I'm so sorry. In a question from Sir Jonathan Cohen, just above D, in relation to the exercise that the bank had carried out to try to prove, and Sir Jonathan Cohen rejected that evidence because it was based on information provided by the bank. But Sir Jonathan said, I do not understand why this exercise was being done in the first place and who commissioned it. I asked Mr. Hussain to to effectively undertake the exercise on my behalf because I had a concern that we would end up in this situation where the letter which has been effectively drafted would be held against us, held against me, to inaudible things that I have from the, and I interpolate, I've got money.
Could you give me the page reference?
I'm sorry, my lord.
No, please don't apologise. I was assuming something. Just literally.
Supplemental 497, just above D. My lady, before returning to the cross-examination and the evidence given in the trial, I would like to make some submissions in relation to what Miss Bangay said about conduct, because it may be important if that is her understanding. Conduct in 4.4, as my Lord Justice Baker said yesterday, is retrospective. Issues, for example, of add-back or bad behaviour, which would fall under section 25.2g, are retrospective. What happened before? He went to Monte Carlo and spent £1 million and I want that added back into the proceedings, or bad behaviour. It is not prospective. And the reason it cannot be prospective is because you don't know whether someone has not disclosed something until you get the Form E. You may not know someone hasn't disclosed something until later. So it must be retrospective, which is why the Svetkov and those authorities look at not reserving your position, pleading at the first instance, and all the directions about pleadings. My Lord Baker, if I may very respectfully say, absolutely right that there's a different issue with 25.2g about the distribution of the assets that you found to be there because of an aspect of someone's behavioural conduct, separate to 25.2a, which is the establishment by the court of what the party's resources are.
Nevertheless, Miss Bangay told us that the established practice in latter years in the family division and or in the financial remedies courts has been to require pleading or notice to be given of the point at the earliest opportunity. I paraphrase what she said, relying on Mr. Justice Peel, relying on Mr. Justice Mostyn.
I don't know of that practice. Sometimes, if there's a specific allegation that comes up during the proceedings, the court might direct, in a specific case, pleadings. If one looks at terms authorities for a moment, Adodo and Tan, which is in the supplemental authorities bundle, it's tab 2.
Sorry, are we moving away from
No,
the transcripts?
we are, yes, my lady.
At the moment,
Sorry.
anyway. So authorities tab 2. No,
Supplemental authorities, tab 2. Yeah. page 31, which is 942 of the Family Law Report, and paragraph 67. And rather than me reading it laboriously out, can I ask my lady, my lords, to read paragraph 67?
Yep.
And there are some cases, like I tried inelegantly with an allegory to Sir Jonathan, some cases where you can make a specific assertion because you have knowledge about it as to non-disclosure, and there's some cases which you can't. All of the authorities my learned friend referred you to were in relation to adversarial proceedings. We are not, as this court and many other courts have repeatedly said, financial remedy proceedings are not adversarial, they're inquisitorial. The system breaks down if my client, a wife not in possession of the documents, having after them and having a duty to disclose them on the husband, is required to plead the non-disclosure when she can't put her finger on it. How could she do that? Which is what I said in my opening. And if one looks at my client's Section 25 statement, which is sorry. The core bundle, my lord. Thank you, Mr. Harvey. It starts at page 155, and she says, first of all, under the heading of conduct, which was the main complaint by my learned friend Miss Bangay, 175, she said, I don't accept his disclosure.
Sorry, what paragraph are we on?
175.
Page 175.
Page 1.
Sorry.
Paragraph 82, the last paragraph.
Yes.
Yeah.
And regarding what she says, to the extent she can, about his resources, she says on page 166 of paragraph 49, that she doesn't accept it. I won't take you back to it, but paragraphs 2 and 3 of my opening skeleton argument make it clear that we're asserting he's got other resources and he's not been honest about his disclosure.
Could you just give us a reference for that,
Yes,
please?
of course.
Miss Bangay, having made the submission she did about
The transcript.
late late assertion of your case.
So it's in the supplemental bundle. Page 3.
This is your opening note or skeleton argument
For the trial.
for the trial,
Yes.
at the start of the trial.
Yes.
And I think the date is 11th of October, and that's on page 25. Is that right? Trial started on the
Yes.
16th.
Yes.
And your case at that point was, we don't know what the husband's position is, so the court's going to will not be able to work out precisely what the assets are. We'll have to proceed on that basis, in line with the authorities that provide for that eventuality.
Mohair. Precisely, and I quoted Mohair in my skeleton argument. So this is what we're going to be doing. It's
Yes.
inquisitorial. We're going to have some evidence. We can't point to a specific sum. There are some cases where the court is able, with some precision, to work out what the hidden assets are, and there are some cases which it has to take, to use a better phrase, a broad brush approach, or do what it can as best it can with the evidence that it hears to ascertain what the assets are.
Yes. There's a long quotation from Lord Justice Moylan's judgment in Mohair.
Yes. Can I ask you then to, I know you've read it, my lady, my lords, the exchange on page 202 of the supplemental bundle. Which is Miss Bangay's, probably starts better at 201, I'm so sorry.
So this is Miss Bangay's protest.
Yes, exactly. And you've been taken to the passage about where I refer to the Swiss bank account where you can assert positive evidence, and me saying in this is a case where I cannot do that, but the court nonetheless has to hear the evidence and it be tested. Possibly the best example of a submission made by Miss Bangay which was simply incorrect and should be corrected by her was the submission that she knew that there was going to be any suggestion that the accounts were genuine was in my closing submissions. And that is not true. We'll look at some of the cross-examination, but if I could ask my lady, my lords, to turn to her own closing submissions, which came before me in order.
Just a minute. So where are we on the timeline then?
This is after the evidence is completed.
Yeah.
And Miss Bangay goes first in her closing submission. So before I have closed my case, she goes first. The assertion that she made to you in writing and orally was that she didn't know the case I was running about the disputed accounts until I spoke.
Had she had your updated schedule?
So first of all, she had the updated ES2, which had that number on it
And she got that
the night before.
And did you receive the paper version of her closing submission, either in soft or hard copy, the night before or on the morning?
I can't recall, probably
Probably the morning, I would think.
the morning. But can I take my lord to my lady, my lords, sorry, to her closing submissions, which came before mine, and it's in a supplemental bundle. At the bottom of page 318. And can I ask the court to read through, please, to 321.
So this is her oral submissions.
My lord, yes.
Yes. Where do you want us to start?
The bottom of page 318.
Bottom of the page. So,
Yes.
I'm going to take a deep breath.
Yes.
so just, so you didn't have any written closing submissions?
I think they're
The bullet points.
I
Yes.
think they were bullet points.
Okay,
I don't
but
want to
this is
mislead
the
the court.
orals. These are the oral submissions.
But the reason this is important is to put to. I say she should correct the record.
I know.
Address her submission.
I know what you're saying. I just wanted to see whether or not I needed to be cross-referring these oral submissions to a paper document.
No.
Right. I'm going to take a deep breath and read
Thank you.
318 and 319.
Through,
321.
please, to 321.
Ah, right. Thank you.
The top of 321? Or
That's probably sufficient.
So you don't want to take us to the submission at E on 321 that says there isn't a single claim my client has ever not complied with orders of the court and there's no reasonable basis for the wife of alleged material non-disclosure.
Yes, my lord, I probably
would
should.
like us to read that?
Yes, please.
sure, I probably led you astray.
But it was just the specific point about not knowing there was going to be a suggestion about the account. But my lord, thank you.
So I just want to know where I'm supposed to stop reading.
And then the asset schedule that Ms. Bangay refers to at F, is that your new one?
Yes. So in my respectful submission,
Stops.
sorry,
Mr. Curran. Carry on, sorry.
in my respectful submission, she knew it was an issue by the time of her closing, and no one could have sat in that court and not thought there was an issue about the genuineness of the accounts and the money that was asserted in those letters to be there.
So at the bottom of 321 at G, Ms Bangay says, so my lord, shall we just do it asset by asset? That's by reference to the new asset schedule. Did she then do that? And should we read what she said about the letters?
It stops there.
That's
Doesn't it go on? No, it doesn't go on.
No, it's truncated. I will ask Mr. Haggie, who has a full,
He's got the whole lot.
the whole transcript, to have a look.
Just if he could
may
be kind
assist.
enough, and perhaps Miss Bangay's team as well, so that everyone's content that we're being fair. Just see whether Miss Bangay then did specifically deal with the letters when she went asset by asset. That might be helpful. Yes.
So, shall I continue?
Yes, do.
Thank you. I want to now deal with some of the cross-examination and the letters and how the genesis of it. My client, in fact, would be completely unable to positive case about them, make submissions. She did not see, she's not internal in the bank, hasn't seen the accounts, can't say I saw the document or not. The curious thing about the first part of the cross-examination, when we only knew there was one account, and my lord,
You mean
my lady,
one
my
letter?
lord. Sorry?
You mean one letter?
One letter, I'm so sorry. 5 accounts. Well, can I actually, it might be a good point to look at what the letters actually say, because it's not an account. The reference to it being an account comes from the husband's witness statements and the bank's witness statements, which they then sought to disavow. If one actually looks at the letters themselves, which are in the core bundle, page 103, and subsequently 104, it says, we confirm that you have, as at the date of this letter, funds available as follows. Deposit 1.
Do we read that as a reference to an account?
Who knows? Because it could either be an account in the husband's name, it could be, for example, it could be a reference to an account IIB Bank re SF initials. We don't know the form that reference to funds being available takes within the bank's books, which is one of my submissions in relation to the work from Ernst Young, because they looked at whether there was a name on the account saying, with the husband's name on it, Sahal, Sultan, Ahmad, or it could be IB reference SSA, which is why they didn't spot it, or it could be any nomenclature on the account. It could be a term deposit, it could be any manner of arrangement where the husband had these funds available to him. So I just wanted to address you in relation to what has become known as disputed account.
But they're separate, aren't they? Is it not reasonable to assume they are 5 separate accounts?
Well, they're 5 deposits. They're 5 funds which he has available.
In different denominations?
Yes.
Some in dollars.
The likelihood may well be that they are in an account. Doesn't necessarily follow that the account would be in the name of the husband. Might be more likely than not. But I want to...
Doesn't matter for your case.
It doesn't matter for my case. So, and the timing of that letter is also important, because the first one was the 30th of June. The husband's witness statement in respect to the non-molestation proceedings was, I think, the 29th of November. That we looked at before, which page 105 it starts. But the second letter was the 2nd of November 2020. So at the time that he made his first witness statement, the second letter had been drafted and signed only 27 days before. But as my lady, my lords, collected from yesterday's exchanges with Miss Bangay, the existence of there being a second letter was only understood or known to us at the end of the husband's cross-examination. The case in relation to the accounts was put by me in the alternative. Either they're a sham. This is your case. Your case is when the CFO of the bank, chartered accountant, signs a letter saying the husband has deposits of $20 million available to him. That's a lie. And your case is that the witness statements with the statement of truth, signed by both the CFO and two by the husband, are also a lie. And also that you conspired to pervert the course of justice by discussing the contents of the witness statements and then both making statements which were lies to the court. That was their case. Now, clearly, this court and the court below might understand that when we were running a case of sham in relation to the FAP, admitted shammers and perjurers and those who are conspiring and admitting to conspiring to pervert the course of justice may be a very relevant matter. But the cross-examination was in the alternative. They might be true, in which case you've got lots of money, and they might be false, in which case you're an admitted shammer and perjurer and conspiring to perjure.
In which case you said that would go to the credibility in relation to the
sham.
The sham.
Centrally. So we looked yesterday
Either way, your case was there are more assets than you're letting on. Either it's true and you're letting on, or it's false and you're a shammer, you're a behaving deceptively, and therefore the court can infer more assets.
and the court should properly have assessed the question of their admitted shamming. I don't know if that's a word. But what they was
Deceit.
yes, and we looked at whether or not you had to rely on the document for it to be a sham, and you don't need to. The fact that you sign a document which is false and intended to deceive, the fact that it's deployed or not, doesn't affect what you're doing. So it either meant that the husband had $20 million as at November 2020, or he was conspiring with Mr. Hussain, the bank, to produce two, as it turned out, sham documents. He also conspired with Mr. Hussain to perjure themselves, because it was admitted during the cross-examination they'd discussed the witness statement. That's why Mr. Hussain's statement is exactly the same as the husband's. And the husband perjured himself twice in respect of the LASPO statement and the non-molestation statement. And the bank perjured itself once in relation to its affirmation that there were blocked accounts, which must have been relevant to the court's assessment of whether the fact was genuine or not. Now, you looked with Miss Bangay at some of the cross-examination of the husband, which I won't repeat because I know that you have seen it. But I would like to look at some of the cross-examination of Mr. Hussain in relation to this issue, which I don't think you looked at in the same detail. I'm sure because of what my lady said yesterday that you've read it, but I would like to highlight, if I may, some parts. So we are, if my lady, my lords, would turn to page 261 of the supplemental one. And by this stage, just to put it into context, the first letter had been produced. And at some point during Mr. Hussein's evidence, the second letter was produced. And you asked my lady, if I may respectfully say completely correctly, I thought they'd been shown to somebody, and you're completely right. Because if we look at page 261, this is the discussion about why there were two letters produced, and it starts, if my lady, my lords, will read it D on 261. The answer for Mr. Hussein, contrary again to other evidence that he had given, so this is the bank's own evidence, because we had shown, I think by the time it had got to doing the second letter, there was some movement. And then I picked him up on it, because his evidence before was that they were never deployed. We weren't really shammers because we didn't deploy them, we didn't use them. And then he backtracks on that. And then the cross-examination goes on over the page, some questions from Sir Jonathan.
Sorry, sorry, I can't understand that. You were suggesting, were you, that the fact that the figures were different indicated that the letters were genuine?
May I go back one stage? There was a discussion or debate or cross-examination, or I can't remember what form, that there, I think Ms. Bangay said, well, there weren't shammers because they didn't deploy, the documents weren't deployed. And my submission was, if you create a document intending to deceive, which is false, you are a shammer. The fact that you don't deploy it doesn't mean that you have put it into practice, whether it's an inchoate offence or whatever it might be. That passage was about whether or not he had shown it, which was contrary to other evidence he'd given that they'd never been deployed. So a further lie to the court or contradiction or misremembering, whatever it might be. The questioning then developed when we saw the second letter. Why would you, if the first letter had not been shown to anyone, why not just change the date? Because you wouldn't need to alter the figure. If it was a complete lie, never had these accounts, never had these funds available to you, it doesn't matter what numbers are in there, so long as they're...
Yes, we can see that's what the exchange was, and the judge picks that point.
Yes.
You say that the implication or inference was that was evidence that the letters were genuine.
Yes.
Yeah.
Absolutely. Sorry, I maybe misunderstood.
Because if they... Yes. Thank you.
Like, why bother?
I think there's a passage, isn't there, where the movement in the figures is explored in a bit more detail.
It is. And the explanation...
So in a way, the answer to my Lord's question ought to have been yes. I did explore why the figures were different.
Sorry. And then I misunderstood the question, then yes, that was why it was being explored.
Yep.
And we then looked at, on page 262, that whole page. Can I ask my lady, my lords, to read 262, please?
So
And
we've still only got the first letter at this stage.
No, by this stage we've got both letters, which is why we
Of course,
are
that's why
able to
sorry.
identify the difference in the numbers.
Of course.
Sorry, can I ask you to look at 262 through to 263?
Oh yeah, we'll have to produce the one from November overnight, so haven't actually got it.
Got the second.
No.
But you know it exists.
No, it know
Yes.
about it, and you know the dates, the amounts different.
And through to the middle of 264. So this is evidence, what we say, of Mr. Hussain, the CFO of the bank, chartered accountant, admitting on his case that he conspired to pervert the course of justice. Can I take something out of term? A learned junior, Mr. Haggie, has found the matter that was asked in relation to the submissions by Miss Bangay, if it's not going to be inappropriate for the court for me to do that. So about 3 pages on, I'm told, Miss Bangay says the following to Sir Jonathan Cohen in relation to the line-by-line ES2 issue that my lady, or my lord, will just make a pass.
So where am I looking at?
You're not. It's not in the bundle.
Oh,
I'm so
sorry, yes. So he's read on. And
apparently, sorry?
It's been sent to your clerks, my lady.
thank you.
Thank you. But may I read out?
Certainly.
Or is that all right? Or do you want me to wait until you've got it?
How long is it?
5 lines.
Well, just read it out then in that case.
Miss Bangay says, Euros, this is dealing with the line-by-line asset schedule. Euros 100,000. It was a steal at the time, and it had gone up significantly in value. And the fact that, frankly, Mr. Hanani effectively offered 200,000 suggests that he knows it was worth far more than that, far more than that. Right, my lord. If we go to bank accounts and cash, we have a new entry. The wife is asserting that my client has inaudible the accounts the princely sum of £16 million. Hence it is highlighted in yellow. So there's no doubt that she knew it was an issue because we put it in the asset schedule.
No, well, she's not said it wasn't. She knew it was an issue. What she's complaining about is discovering it by way of the schedule of assets the night before.
Well, no, because her written skeleton argument says that the first she knew that we were going to be asserting that he had this money was in my closing.
No. Well, I understand what each is saying.
Very well. Can I return, if it would be convenient to my lady, my lords, to Mr. Hussain's, the cross-examination of the CFO? So, can I ask you to look at page 274 of the supplemental bundle? At F. And ask the court, if I may respectfully do so, to read to the end of 278.
The other possibility is it's genuinely true.
Yes. Can I ask my lord to, my lady to
We
read?
looked at this yesterday.
We did, but the whole passage is important.
And I assume you also want us to note at 273 at line B that the second letter has been produced overnight.
My lord, yes, thank you.
Yeah.
Could you just tell me the reference of the letter from Mr. at 276 from the chairman, just so that I can write it on the transcript? Have you not got it?
Which
Haven't
lot?
you
I'm
got
so.
it?
I couldn't find it.
No.
Mr.
Have you
Ferreira.
found it?
No.
Which may I? Which
So
line?
top of 276.
Yes.
A.
Yes.
This is a letter from Francisco.
Yes,
Ferreira.
we do have it. It's in the supplemental bundle.
Right.
It's the so Mr. Ferreira was an employee of, if I'll get corrected, I've got it wrong, IIB CAP, which is where the letter
Absolutely.
which says that they've got the funds were deposited. So
Yeah. So he was in charge of that part of the bank
yes,
where it was the letter said the funds were deposited.
yeah, well, yes. Mr. Haggie's finding it momentarily. It's in the.
We'll carry on reading while he looks for it.
Yes, please. Thank you, my lady.
Yeah. Well, we see a quote from it. You say those were weasel words.
Well, we went through this with this banker.
Yes. The reason I want to take you to it is because by this stage, Mr. Hussain, CFO, and the bank, and the husband were on the horns of a dilemma. On one case, they were perjurers, shammers, etc. On another case, their attempt to tell the court that they were shammers and perjurers was itself a lie. And the documents were genuine. And it's in that context, when they had had 4 or 5 days of cross-examination where the husband had to say, I'm a liar, repeatedly, I'm a shammer, I've perverted the course of justice. So did the CFO of the bank. That was their case, and it's putting the alternative that either the court could believe them when they say they're lying, or the court could say, well, you're lying now because you don't want the court to find that the husband's got $20 million, and that's why you're saying all of these documents are a lie. It's in that context that the representation, the offer, the discussion about the bank purchasing a property for the wife was made. They were absolutely backs against the wall. They faced a situation where the court, potentially with a public judgment, was going to find these two individuals who control the bank, one of whom is a chartered accountant registered in this jurisdiction, to be, I don't want to repeat it again, but have done all of the things multiple times to this court, or to the court below. It was in that context that Mr. Hussain made the assurance to the court that they would buy another property for the wife. And I want to then look just for a moment at the fact, if I may. Because the FAP had not been known to my client prior to receipt of the husband's Form E. It is and remains a very curious document. The document is obviously in the bundle, but there was discussion about what the parties, i.e. the bank and the husband, could do in relation to this agreement. So if my lady, my lords, turn to the supplemental bundle, page 468. Can I ask the court to read 468? Sorry. Through to 471.
Just so we know, what exactly is this?
Cross-examination of Mr. Hussain, the bank.
Okay.
So he says, I know nothing about the husband's finances, even though he's written 2 letters, which he now disavows. The FAP would expire on the 3rd of February 2024, just conveniently after the commencement of the proceedings by my client. It's got a date of 2024 when, on their case, the husband's got no money. On their case, just got a salary. The Hawes Akbar, the GA litigation, isn't going to fall in till 2031. So how has this date been created? Why is this date being created? It's our case on sham, never intended to be implemented. To create the impression that there was an asset on the bank's books which was always going to be extended, always going to be put in perpetuity. Because if this family, if it was a continued living there, they didn't have the money. On the husband's case, didn't have the money to buy out the bank. Never intended to be enforced. So by this stage, the bank and the husband are completely on the horns of a dilemma, completely in a pickle. So the judge is then inquiring whether or not, in that context, potentially to save their blushes, he asks whether a different property would be able to be purchased. And because the irony is that despite these 2 individuals at pains to say that they had been dishonest, thoroughly dishonest, the judge believed them in respect to the disputed accounts and believed them in respect to the fact. That's the irony in some ways. And just after Mr. Hussain gives his evidence to the court, saying, yes, I would do this, and knowing the difficulties the bank are in relation to public findings of dishonesty, potentially reference to Chartered Institute of Accountants, regulatory difficulties in Bahrain regarding their honesty and ability to continue as CEO and CFO, Mr. Richardson gets up on page 471. And can I ask you to read through from 471 through to 475, 473.
Do you mean 471?
I hope I do.
Or do you mean 475?
Well, 471, it begins.
What, Mr. Richardson's, my lord, do you mean an extension of the lease or extension of the plan?
Yes. And then probably, as my Lord Fraser said, probably to the end of 477.
But the point at which some flesh is put on the bones isn't it? 475 at letter E, where Mr. Richardson says having taken instructions over the shorter journey.
Yeah, but
just putting it in context.
But the context is important because you've got Mr. Hussain, the CFO, saying, we will do this. My Lord, we will do this.
Well, I don't think we can always read all that pages and pages again to ourselves later. Let's just pick out where we're going and why.
You then have
the context would be important if you were asking us to construe the terms of an agreement, and we need the background knowledge of the parties.
Well, this is where what we would say, Mr. Richardson's very eloquent submissions have led you down a cul-de-sac. Because this was not an offer being made to the wife. This is not the bank saying, if you drop the FAT claim, we will buy you a house. That's not what was being said. This was a representation being made by leading counsel to a High Court judge saying, we will do this. If you find that the fact is genuine, i.e. that we're not shammers in relation to the fact, we will buy the house, the wife a house. There's nothing for the wife to accept because it was not an offer made to the wife. This is a representation made to the court in terms, if you find the fact to be a genuine document, we will buy the wife a house. And what Mr. Richardson, let's say the court said, well, what power do I have to order you to do that? Mr. Richardson would have to say, well, this is what we're going to do. We're assuring the court, substance, not form. And what the bank wants to do now is say, well, I don't want to do that anymore. Whether there's an estoppel argument and common law, whether the bank is stopped, whether it's binding heads of terms, but it is clearly an approach which the court considered it had available to it, which is why when we look at the judgment,
I think the judge was pretty ambivalent about whether he could do it.
well, but let's not look at the consequential. Can we turn first of all to the actual mainframe judgment?
Well, rather than this sort of background, what might have happened, let's just focus for a second on what it is actually you're saying. The validity of the VAT was a central issue in the case, and the judge has heard evidence on it. Your case is that it was a sham. The case that you were meeting was that it was a genuine document. I think what you're saying now is, because of what Mr. Richardson said during the evidence to the court, he was making a representation to the judge of what the bank would do if the judge, instead of judging the case on the evidence before him, were to hold the fact was not a sham.
Yes.
Is that what you're saying?
Yes.
That's quite a submission.
Well, if we look at the judgment, so can I ask you to turn to the mainframe judgment? First of all, at page 89 of the core bundle,
Paragraph, please.
130.
Thank you.
So 130 and 132, 131, please.
Yes.
And then to 150.
Well, he wouldn't have needed to take up the company's proposal if he had made a different finding about the
Yes. That's my point.
Well, I thought you were suggesting that the judge effectively did a deal and didn't make a proper finding in relation to the fact,
Well,
because he wanted to be able to accept the bank's offer, and I find that a very concerning submission.
well, in my submission, the learned judge doesn't explain, and this
Is that your submission?
my submission is that the court was persuaded that and I say nothing of any impropriety on the part of Sir Jonathan Cohen at all.
Persuaded. Keep going.
That it would accept the bank's offer to purchase a property.
In exchange for, you're saying,
If the court found that the fact was a genuine document.
Well, what's the problem with that?
Well, in my
Because
submission,
it wouldn't need to take up their offer if, having considered the case and heard the submissions, you decided that the fact wasn't a sham. Your case, you put it as a plea bargain, your case is effectively the judge, perhaps because of it, on your case, the judge, because he was concerned to protect the wife and children, failed to make the finding he should have done, hence your appeal, so that he could get the offer, so he could nail down the offer from the bank. Is that the way you put it, or have I got that wrong?
I wouldn't go so far as to say that, my lady.
Okay, could you just, you've used the word plea bargain. I just want to be really clear, because I don't want to exaggerate how you put it.
No.
In fairness to your case. So if you could just try and crystallise just how you say, do you say he was duped, persuaded, what is the cause and effect you say on the finding in relation to the fact, as a consequence of the offer made by the bank?
It goes together with our appeal, because what we say is that there was a wholesale failure to address the factual matrix of these individuals when considering whether the fact was a sham. And can I ask you, in that regard, to turn to supplemental bundles?
But just before you do that, just so that, because that is how I understood you were putting it, and I obviously misunderstood what you said 5 minutes ago. Because the part of the judgment where he recites the bank's offer is headed open offers, and by that stage in the judgment, he's already found the fact to be a genuine transaction, which is why he is then, in terms of how he understood the bank's position to have been explained, able to consider the bank's, as you put it, representation or offer. That's a world away from how I understood you were putting it originally, which is he found the fact to be genuine because he wanted
I'm
to
not
pursue
saying.
the offer.
I'm not saying that.
Oh, well, that's, I think, certainly
that case,
how I
I'm-
understood
And how I understood it.
what
In that
you
case,
were
I
saying.
withdraw that.
No,
I
well,
think all
that's-
three of us may have had different understandings of what you were saying. So
In
it
that
might
case,
be
I-
helpful, and this is quite important, Mr.
I understand.
Fraser, if you explain precisely how you are putting this, and how you are saying, in particular, that the exchanges with Mr. Richardson or Mr. Hussain in evidence and Mr. Richardson's submissions affected the judge's findings on the FAP, if they did.
I can't say what went on in his lordship's mind. What I can say, and I would ask you to look at the supplemental bundle, page 61. And these are our written submissions on the question of the FAP.
Thank you.
And can I ask you to read from paragraph 4?
Just give me a moment.
Sorry.
Sorry, thank you.
I'm
Paragraph
sorry,
4.
my lady. Paragraph 4 to paragraph 19 inclusive.
To 9 or 19?
19.
You're certainly giving us some big reads.
I'm sorry. It's important in the context of the way in which the court below dealt with the question of the validity or otherwise or sham of the fact.
Well,
That's your details. I mean,
yes,
if I pick up the lady's point, these are your detailed submissions on the FAP.
Yes.
How do these go to the issue that the question I was posing 2 minutes ago?
It goes to the question of how the judge dealt with the fact, which is obviously part
So
of
is your
our
case
appeal.
that he didn't address all these points?
Yes.
yeah. So we don't really need to read these because we can go back to these in the context of you're
Potentially.
saying that these are the issues which the judge
Yes.
should have taken into account,
Yes.
and he failed to do so.
Yes.
Well, I can see how you might be putting it, but I really, for my part, would like to hear how exactly you are putting it. I think in fairness to say so, everybody, you need to put it precisely, say exactly how you are putting how the exchanges with Mr. Hussein in evidence and Mr. Richardson in submissions affected the judge's finding on the fact.
It appears, and I can put it no higher than this,
It appears, yeah.
because of the fact that the learned judge did not deal with all of the evidential points that we say in relation to the fact in those submissions, and the very cursory nature by which he addressed the validity or otherwise of the fact in his judgment,
Yeah.
he may well have been unconsciously influenced by the bank's offer.
Do you say that possibility or submission should affect the way in which this court evaluates his treatment of the fact?
Yes.
How?
Because the judge's understanding in relation to the bank's position was not, as we saw from the submissions made by Mr. Richardson to the court below, not a we might consider the possibility of doing this when we see the judgment. This was a firm representation to the court about what the bank would do.
Sorry, I didn't make myself clear, and I apologise. Obviously, you know that this court takes a particular line on when invited to review findings of fact. Volpe.
Volpe. Paragraph
Faraj
2.
and Volpe. Volpe to paragraph 115. Faraj. And you're saying that we should adopt a more, a greater degree of scrutiny, are you? Because of this exchange and because of the judge's approach to the offer from the bank.
And also because of the context.
So wait a minute, so the answer to that bit.
Yes.
So you say we go behind the approach to Volpe, or Volpe can be regarded in a different light, because you say this judge was wrongly influenced by the offer of the bank. I know by wrongly you're not saying dishonestly.
I'm not saying
corruptly,
anything inappropriate.
You're just saying subconsciously or something.
Yes, I want to make it clear. I'm not casting any aspersions on the court below in terms of its judicial function, but that doesn't necessarily mean he wasn't influenced subconsciously by the position that the bank offered. And the reason I say that is because of the context in which the whole trial continued, the cross-examination of the individuals, what they were trying to say that they had done to the court, and in relation to their honesty, which the court's ultimate finding was that they were honest individuals in relation to the letters. The
letters were a genuine document.
Yes.
I think it's fair to say honest.
I'm so sorry, I'll rephrase. The letters were genuine documents and didn't find them to be shammers in relation to the FAP.
A different way possibly of putting the point might be you're relying on the framework within which he considered the issue of the fact being a sham in his paragraphs 52 to 57 as cursorily as he did because of the existence of the bank's position on rehousing the wife and children.
May I adopt my lord's?
But is that what you mean?
Yes.
Because he expressly says it's not necessary for him to set out the principles and authorities relating to sham transactions, as I do not find it to be a sham. Could be said to be possibly the wrong way round. Look at the principles first and then decide if it's a sham. But that point only arises on your appeal, I think.
Yes. And 57.
It doesn't arise on the bank's appeal, does it?
Well, it goes to the extent to which, and we'll, if we may, in a moment discuss the nature of the assurance, the extent to which the bank is able to say to this court, I don't have to do what I assured the court I would do. Now, whether that's under an estoppel or an abusive process or something else, what the bank says to my lady and my lord is, even though I gave an assurance to the court below, and the court below relied on that assurance or accepted the bank's position, I'll rephrase.
You're back to saying
I rephrase, my lady, I apologise. I rephrase. Accepted the proposition, which at paragraph 157 says, I'm satisfied that this is an outcome which is fair to both parties and one which will leave each being able to meet their respective needs. That the bank is now estopped from reciting from its assurance to the court that it would do this.
But I just don't understand, because the judge made an order that the husband is to pay £6 million to the wife, of which it specifically says 2.2 is it. It is for housing.
Yes.
So why would the bank need to do anything?
Because the availability, getting those funds, may be more tricky in circumstances where the money is in Bahrain and the husband disavows that he's got them.
But can a judge, this is a question I've been thinking about, can a judge approach the case and the outcome of the case on the basis, I'm going to make this finding, I'm going to make this order, but I don't think the husband's going to comply in a million years, and therefore I've got to have some sort of a backstop arrangement to make sure that the statutory provision that the first consideration of the wife and children is satisfied, and the only way I can do that is by making a third party provide accommodation.
Well, this was...
I mean, that's what you seem to be saying.
The genesis of this was that the bank were under no... Before they made this assurance, or gave this assurance to the court...
Offer.
Proposal. And suggestion.
Well...
whatever it is.
We say it's more than that, but anyway, ignoring the name...
Whatever it was, yeah.
That the bank was under no obligation to do so. I accept that. But what we say is that the position changed dramatically through the course of the case. Mr. Hussein's evidence saying that they would do this, an assurance to the court by the CFO that they would do this, and Mr. Richardson's submissions thereafter confirming that to the court. And it wasn't, in my submission, it wasn't an offer to the wife, it was an assurance to the court that this was what they would do.
And when you say he concluded at 157, I'm satisfied this is an outcome which is fair to both parties, we'll put that to one side, and will leave each able to meet their respective needs. You're saying he takes into account his understanding of what the bank would do in reaching his conclusion on needs.
Yes, and if one looked at 160, his lordship recognises the potential difficulties about monetising the award. But in the meantime, because he accepts what the bank has said, he is willing to make the orders that he did.
So all of that, therefore, just means I've got to repeat the question I asked you 5 minutes ago. That's relevant on your appeal. How is that relevant on the bank's appeal?
Because what we say is that it is unconscionable and the bank is stopped for the reasons, and we'll look at Malik, which obviously Malik was part of the constitution of the court, from reciling from its assurance to the court. And his lordship made it plain to Mr. Richardson in submissions that all options were open. All options were open to the court before it considered it. And Mr. Richardson pressed the assurance to the court in relation to the purchase of property. And what we say in relation to the bank's appeal is that they are therefore stopped from withdrawing that assurance to the court.
Well, that opens up a whole string of points, doesn't it?
It does.
Because we'll have to deal with, presumably, with what Mr. Richardson says about what happened after.
Well,
He put the idea in the judge's mind. I can use another phrase.
what we say about what happened afterwards is what we say about what happened afterwards is that cannot unpick what happened before. I mean, the court did not have a full transcript of the submissions made, the evidence before it. So the discussions in relation to the perfection of the order were not done on the basis of full submissions in relation to the status of the words used by the bank. And what we say, sorry, I didn't mean to.
No, you finish.
What we say in relation to the bank's appeal is that, first of all, it is premature because under FPR 3 paragraph 1, the court can adjourn proceedings for the parties to have discussions, non-court dispute resolution, which is exactly what the court ordered the party to try to reach an agreement, and if they can't, come back to court. So, and this is in answer to potentially a question that my Lord Justice Fraser posed yesterday, but all the court was doing in paragraph 10 was adjourning a decision. So we say that paragraph FPR 3.3 is exactly what this court, the court below, did. Secondly, that there has been no first instance resolution and decision on the status of the words used by the bank. Because that would only happen if there was a dispute following the order at paragraph 10. So to take this in turn, the bank would then say to the court below, well, that was just some words that I used, you can't bind me. There would then be an examination by a first instance court of the status of those words, a judgment, full argument about estoppel, etc.
Can I ask, don't you on an estoppel have to prove you've acted on it to your detriment?
That's why the case of Malik deals with the question of abuse of process. So what we have is a situation where in deciding that the parties, and especially the wife and children's needs were met, he was relying on the assurance, the offer made by the bank, that it would buy her a property.
But on the basis you've explained the power the court has generally to resolve disputes if they don't reach final agreement. On the basis the bank issued a notice seeking permission to appeal paragraph 10, and obviously no longer intends to house the wife and children. So far as the bank's appeal is concerned, that appeal is against the order, isn't it?
It is, and the specific paragraph which is said to be offensive within that order or ultra vires is essentially a paragraph which says, please go and discuss this with the other parties and come back if you haven't reached an agreement.
But which the bank have explained, having shown us the travelling drafts, etc. There were various discussions, they didn't get anywhere, and now the bank's trying to have paragraph 10 removed. So we're not exactly going to say there's been no first instance resolution of the difference between the parties.
So there should have been, what we say is the bank returning to court for a hearing post paragraph 10, where we would be saying, for example, that the status of the words used by the bank binds the bank, and they can't resile from their position, which the court below relied upon in finding that my client's needs 25(2)(b) and first consideration were met.
Why can't we deal with that?
Well, because
Now we're here.
well, I'm of course not saying that this court can't, but the usual position would be a full argument about the status of the words used, exploration of.
That's what we're doing here now.
Well,
that's what we're doing for the last several hours.
Very well.
So, for my part, I think we can park that point about
Very well.
what they should have done. They haven't done it. That's not the answer to his appeal now, is it?
Well,
It's the bank's appeal for giving us.
If the court is going to go on to consider the status as effectively a first instance tribunal or court of appeal, considering that question, then of course it can. I'm not suggesting it can't.
Can I go back to FPR 3.3?
Yes.
Took us to. But that's very different. That's the court's duty to consider non-court dispute resolution. That's not talking about the parties standing outside court or in their solicitor's office or by exchange of emails to see if they can sort stuff out. That's mediation. That's formal dispute resolution. And in any event, that doesn't help you on whether the court then has power, failing that, to impose an order.
I understand that. My submission was in relation to paragraph 10 and what the effect and the intention of...
You said it was premature for the court. You said in support of your submission that it was premature of the court.
Yes.
You said because this was covered by 3.3.
Yes.
And that's what the judge was doing. Well, he wasn't. He was just saying to these parties, go away and see if you can sort stuff.
Yes.
He was not applying 3.3, considering the court's non-court dispute resolution.
Well, I've made my submission. You may
But
find
you
against
say
me.
he was.
The effect of paragraph 10 was to...
Sorry, I'm just passing.
Of course,
he's
of
not
course.
familiar with the.
We haven't got a red book.
And 3.41b.
Can I ask, what do you understand the judge was going to adjudicate upon in the event that the first part of paragraph 10 got nowhere?
May I just turn up
the order.
the order? Sorry.
No, I've turned it up about 1 million times so far. I should know it by heart by now. Liberty to apply for adjudication on the issues on which they disagree.
I'm so sorry, my lady.
Liberty to apply
Yes.
to the court for adjudication on issues on which they disagree.
Yes.
So what does that mean?
That if the parties could not agree on the
Fine detail.
fine details.
Well,
I think changing it from being a term trust
Yeah.
to forever to be able to buy it at the current rate
So
is more than fine detail.
Yeah.
and do the parties include the bank? Just so we're
Yes.
clear about that.
yes,
But doesn't the judge say in the judgment somewhere, you can't force the bank to do something they don't want to do? They're not.
well, that's in the second judgment.
Second judge.
And what I say about that is that one has to look at the first judgment, not what he remembers or considered in relation to the evidence, the transcripts, the evidence, the submissions. Because if it is the case that by the time of the first judgment there is an obligation on the bank to do so, then the fact that he might subsequently not remember the full exchanges and have a different view
Well, what can he do? What can he do
in
to
relation
order the bank? What can he do to order the bank to do something?
well,
Third party.
in my submission, the assurance by the bank means that the bank is unable to resile from its assurance given to the court, which it did rely on when considering the exercise of its Section 25, the Section 25 criteria in deciding that the parties' needs were met.
But Mr. Glaze, there's an air of unreality about this because I can accept entirely the mechanism in an order to allow parties who are fundamentally agreed about a transaction, but who can't agree all of the specific fine details, can return under liberty to apply to have those differences decided by the court. But this is rather different from that, isn't it? Because as soon as Mr. Richardson lodges his application to appeal, it is obvious that the bank are not prepared further to negotiate, discuss, agree with the wife about buying her a house.
Yes?
So if that's the fundamental difference between them, liberty to apply provision to go back and discuss or have adjudicated details falls away or turns into something much more significant, which is, could you, under the liberty to apply, ask the judge to order the bank to buy her a house? And there's got to be quite a simple answer to that. It's either yes, the court can do it, in which case how, or no.
Well, in our submission, the fact that the offer clearly was relied upon and influenced the judge in his overarching assessment of how these parties' needs were going to be met meant that if, and we don't accept this, if it was the case that the offer was going to be withdrawn before the learned judge below, then there would have to be reconsideration of the Section 25 criteria and whether my client's needs would be met.
Is that covered by any appeal before us at the moment?
But it's covered by the appeal in relation to if the bank's appeal is allowed, it should be remitted for a rehearing.
Rehearing of what?
The case. Because
The whole
if
case.
if it's the case that the bank now says,
But you've got
contrary
an
to the-
order.
sorry?
But if only the bank's appeal was allowed, you still have an order that says this husband has money, he has to pay a lump sum of £6 million, of which 2.2 million is dedicated to buying a house. And then you have means of enforcement.
Well, sorry, I didn't mean to interrupt.
Well, that's the point, isn't it?
Well, there's an overarching question about the extent to which my client, her vulnerableness in her accommodation, because of the FAT's expiry shortly after the date of the trial, was considered by the court in coming to its overarching decision that my client's needs were met when it said, I accept the bank's offer.
Why would there have to be a complete rehearing? I'm sorry,
Well,
I interrupted. Sorry.
Because you're wanting to uphold that the husband's got the money.
Yes.
So if there's going to complete rehearing, that's up for grabs as well, she says colloquially.
Well, I understand that. Maybe I could consider that issue about the effect of our appeal and the bank's appeal in relation to what is remitted for a rehearing.
It may be that what you ask, you can do no more than this, and I'm not saying I would agree with it. Maybe all you can say is that if we extract paragraph 10, then there has to be a reconsideration of the order on the basis of the facts found by the judge,
Well, what
subject to your appeal.
I was just about to say,
Subject to your appeal on FAB.
yes, that we would be saying the other facts should remain undisturbed. The question of the sham in relation to the fact would have to be, per our appeal, reconsidered in light of the failure, so we would say, of the court below to address
Okay, but if you've got that point, which you haven't come to yet, of course, but if you don't succeed on that point, and if Ms. Bangley doesn't succeed on that point, the highest you can put it is this: is some court, either us or somebody else, has to consider whether removing the bank from the whole equation, paragraph 10 of the equation, requires a re-evaluation of the section 25 criteria on the facts found by the judge.
I understand, of course, and what I just want to go further on this point before we break, subject to the court's decision about when we break. The letter from the bank solicitors was a very unattractive one, because effectively they were holding the court to ransom, or the wife to ransom, saying, don't enforce a decision that you've got that the husband's got some money, and then we will buy you a property. But in relation to my lord's...
You're moving off that point, though, aren't you?
In relation to my lord's question, I can full well see that this court may remit the question of the overarching section 25 criteria and the security offered to my client if the bank withdraws its offer.
Why would we have to remit that?
Well,
I mean, and I know you may want to think about this in a couple of times, but my question is, if Miss Bangley fails and you fail on your point, and all that happens is the bank, paragraph 10 is extracted, does there have to be a section 25 re-evaluation? First point. Secondly, who should do it? Thirdly, why can't we do it to save a further round of costs, delay, heartache, etc.?
Firstly, yes, sorry.
You can answer it now if you want. But that's...
Yes, I'm going to answer certainly the first question and the second question. Yes, there would have to be another re-evaluation of the section 25 criteria.
Right.
Yeah.
Is that both questions?
There were three. I think the second one was who should do it, and the third one was why shouldn't we? I think.
There's a bit of rhetoric in my question.
Sorry,
my question is not.
I don't mean to be impolite.
No.
Well, there is a question subject to.
Why don't you think about that?
Very well.
And I've got one point. There's some documents that we mentioned this morning, which I would like to see by 2 o'clock, please. One is a bit of transcript, which isn't in
Yes.
the bundle.
It's just now through.
I didn't realise that. The other is we were told, Mr. Richardson, there'd been an extension to the long stop.
Yes, we were, and I asked for that.
We haven't got that letter.
I've got it on WhatsApp, my lord. I'll see if we can get copies of it over the short adjournment.
Please.
Excellent. Thank you very much.
Very well. 2:05, please.
Right,